Hello everybody, today is 5th of August. My name is Sahil and welcome to the newspaper analysis. Guys, in today's video, we will be taking up the entire analysis of the Hindu newspaper and the good articles from the Indian Express explained section also we will be taking up. Guys, if you like the initiative, please do spread our initiative and hit the like button. Now taking up the overview of the articles that we are going to cover. First of all, taking the article from the explained section. So guys, here the Made in India aircraft, the indigenous aircraft carrier has been mentioned. We will see it under the GS paper number 3. Then guys, the Hindu newspaper, this is the page number 1, and the political news issues has been discussed, which is not important for our examination. However guys, here one of an example of conflict of interest has been mentioned and we can utilize it as a case study. We will see that what has happened. Then guys, this particular article onto the city page, it talks about the stubble burning alternatives. We will see that what has happened. Then guys, under the city page, other issues are not very much important. Then guys, here also the indigenous aircraft carriers sea trial has been mentioned. We will see that what has happened. Then the other articles are not important. However, here the Kerala High Court has expanded the definition of a rape. So we will see that what has now happened and how it will be important for the women. Then guys, we reach to the editorial page. It talks about the basically providing the education into the native languages. We will see that what has happened. A good article. Then guys, this particular article talks about the confrontation between the Assam and Mizoram. We'll see. Then guys, this article talks about the crisis that are going into the Ethiopia. Fine. Now nothing very much important is there. Fine. The inner issues and matters have been talked about. Then guys, this article talks about the GST issue. We will see that what has happened. Then guys, going into the next page, this article talks about the role of women into the science. We will see. Then guys, this article talks about the fundamental right to strike. We will see this particular issue what has happened. Then guys, moving on, this particular article talks about the Air Quality Commission bill. So we will see that the Air Quality Commission bill, what it is. Then guys, the other articles are not very much important. However, this particular article, it talks about the fast track special code. So this central sponsored scheme we will be seeing. Then guys, here you can see that the disruption is going on. The bills are being passed without the discussion. Very sad state of affairs. Then guys, the militants into the Kashmir, etc. and all such kind of matters have been there. Fine, nothing very much important. You can leave this particular page. Then guys, here the 50% funds under the MPLADS project, they got lapsed. We will see that what this particular issue is there. Then guys, the RTE entitlements, Samagra Shiksha 2.0, we will be discussing under it. Then guys, further moving, showcase page, not at all important. Then guys, onto the world's page, evolving issues, etc. has been there. Fine, nothing important is there. Then guys, onto the business page also, the corporate profits, etc. they have just been talked about. So guys, just that is all about the today's newspaper overview. And now let's discuss these articles one by one. Now friends, starting the today's newspaper analysis with the GS quote. So today we will be taking a quote from the Martin Luther King Jr., one of the most prominent civil rights activists of US and a Gandhian follower. He says, "Our scientific power has outrun our spiritual power. We have guided missiles and misguided men." Guys, this particular quote points to this thing that the material advancement, scientific advancement has come at a cost of a moral corruption. And now this moral corruption is so extent that the man has forgotten about the ethics. Today we have the generation of the misguided men who are driven by the lust of power, lust of authority, and into this particular regard, the values of humanitarianism, they are forgotten. Today, the mobiles have become smart, the missiles have become guided, but the men have become misguided. So guys, this is the idea which have been provided. Guys, we can utilize it under the GS paper number 4, ethics, integrity and aptitude, the role of human values, as well as into the essays also we can utilize this particular understanding. So that is all about the today's GS quote. And now let's go into the newspaper analysis. Now friends, taking up the first article. So this particular article has been taken up from the Indian Express explained section as well as from the Hindu. We have clubbed both of these articles. And guys, it will be important for our GS paper number 3, the indigenization of defense. Now, what has happened guys? The indigenous aircraft carrier, that is the IAC-1, it has started its sea trial and it is a kind of a momentous moment into the Indian history. Now guys, this IAC-1, it will be the second aircraft carrier of the Indian Navy. Now guys, once it will complete the sea trial and when it will be formally inducted into the Indian Navy, it will be called as the INS Vikrant. Fine. Now guys, we are already having the INS Vikramaditya, which we have taken up from the Russia, and this INS Vikrant will be the second aircraft carrier and it will be solely Indian made. Now guys, first of all, why the name Vikrant has been given to it? So guys, the name INS Vikrant has been taken from the first aircraft carrier of India, which we actually took in 1961 from the Britain. And guys, that aircraft carrier was named as the INS Vikrant. It played a major role into the Indo-Pakistan or the Bangladesh Liberation War of 1971, and it was finally decommissioned into the 1997. So that INS Vikrant we are not having no more, but into its memory, this particular aircraft carrier has been named as Vikrant. Now guys, what is the so much important that we are coming with our own indigenous aircraft carrier? Guys, the relevance lies into the fact that India is aiming to be a blue water navy. Now the blue water navy is one which has its presence in all the oceans, and guys, it can basically act as an intimidating force. So in order to be the blue water navy, we need to have the aircraft carriers, because guys, they can sail much wider into the oceans, and it can give a much wavelength to the Indian naval capabilities. So this is important. Now guys, when we talk about this IAC-1 or the Vikrant as it will be called later, it has been designed by the Indian Navy's Directorate of Naval Design and has been built by the Cochin Shipyard Limited, which is a public sector shipyard under the Ministry of Shipping. Okay, fine, keep it into your mind that it is under the Ministry of Shipping. Now guys, when we talk about the aircraft carriers into the India, we have taken the help from the Russians as well as Britishers. For example, the Russia gave us our present aircraft carrier, that is the INS Vikramaditya, which was refurbished and it was commissioned in 2013, and it is our only aircraft carrier. Then guys, there were two earlier carriers also, that is the INS Vikrant, which was the first one, and the INS Virat. And this INS Vikrant was originally a British built ship that was called as the HMS Hercules, and this INS Virat, it was called as earlier as HMS Hermes. Fine, their names got changed when they were inducted. Now guys, when we talk about the capabilities to build the indigenous aircraft carriers, only 5 to 6 countries into the world are having such kind of capability, and now as India had got that particular know-how, it will be placing the India into the elite club. Further guys, when we talk about an aspiring power, the other powers such as the US and China, they are also having their aircraft carrier fleets. For example, the USA, it has the 11 aircraft carriers. Then the China, it is having it is also moving very rigorously into the aircraft carrier development program. Right now it has 2 aircraft carriers, and the third one is under the making, and the another 2 will be commissioned within a decade. So guys, the China will also be having a commanding fleet. Now guys, it has been provided that we will get the 2 aircraft carriers, but there is a need of an IAC-2 also. Fine, it has been said that we need a third aircraft carrier which might be called as INS Vishal. It has been provided by the Ministry of it has been provided by the Navy that India's coastline is such a big it is such a big unit, more than 7,500 kilometers of coastline we are having, and so therefore in order to protect the entire coastline we need to have at least 3 aircraft carriers. Moreover, in order to venture into the high seas also we need to have the aircraft capabilities. And guys, since 2015 the proposal is being made to the Ministry of Defense that the IAC-2, that is the INS Vishal, should be cleared, but until now it has not been cleared. Guys, there is a view which comes from particularly by the CDS, Chief of Defense Staff, that in Indian Ocean we are basically we are having the Andaman and Nicobar Islands and the Lakshadweep Islands, and they are actually the unsinkable aircraft carriers. So they need to be developed rather than going and making a kind of an entire new aircraft carrier, because the expenditure is huge. If we talk, estimated 23,000 crore rupees have been spent onto this aircraft carrier. But guys, there is again one more argument that comes. It has been said that with so much of hard work and so much of a long time, we have developed actually the know-how how to make an aircraft carrier, and this particular thing should not be wasted. We should continuously go into this particular direction, and therefore the third aircraft carrier will also conserve the know-how that we have got. So this is what has happened. Now guys, when we talk about this particular aircraft carrier, Now you don't need to see that how many crew, how many compartments, etc. are there. But guys, the chief weaponry, it can house 34 fixed wing and rotary aircraft. MiG-29K fighter aircraft can also be lodged onto it. Then Kamov 31 air early warning helicopters can be lodged onto it. Fine, then guys, American built MH-60R multi-role helicopters can be lodged onto it, and the indigenously built advanced light helicopters can also be lodged onto it. Fine guys, so this is all about this particular article. I hope that you have understood it and all the implications with respect to it. Apart from this, you don't need to go too much into the detail. Now guys, if we talk a little bit into the details with respect to the aircraft carrier development program of India, then guys, into the 1999 project P71 was cleared, and it was named as the ADS project, that is the project to build the air defense ships. Then guys, in 2002 and 3, the Cabinet Committee on Security cleared the project to build the aircraft carrier into the India. Fine, it got the government note. In 2006 guys, the earlier ADS program, it got changed to the indigenous aircraft program. And in 2017 guys, the Cochin Shipyard Limited, with it the agreement was signed that they will be building the indigenous carriers. In 2013, actually this particular ship which we are talking about today, it was launched, and now the sea trials have begun. Now these sea trials will be going for nearly 8 to 10 months, and then it will finally be commissioned. So guys, that is all about this particular article. I believe that now it is clear, and now we'll be moving to the next article. Now guys, this particular article taken from the Hindu newspaper, and guys, it we can use as a kind of a case study or as an example. Now see, into the GS paper number 4, there is a topic that is the conflict of interest. Now the conflict of interest is a situation where a person's two interests into the two different domains are colliding with each other. For example, a person is having some kind of a private interest, it got collided with his public interest or his public duties. For example, I am a judge and I am hearing a case, and into this particular case, the person who has been accused of a crime, suppose he is my relative. So now there is the public responsibility of me that I need to act into a fair and transparent manner, but there are the private emotions also which I had with my relative. So there a kind of a conflict of interest might come. So guys, it has been provided that the civil servants, they need to identify the potential conflict of interest, as well as if they are into the actual conflict of interest, they need to find a way to get out of it, so that their objectivity, so that their integrity is not questioned. Now guys, what we can see here, so guys, if you are following the newspaper regularly, we have seen that the matter has reached to the Supreme Court with respect to the water adjudication between the Andhra Pradesh and Telangana. We have seen that the Supreme Court has offered a mediation, but guys, the states want that the adjudication needs to be there, not the mediation. Now this particular matter reached into the front of the Chief Justice of India. Chief Justice of India recused himself in hearing to this particular water adjudication matter. He said that I belong to the Andhra Pradesh and Telangana, and if I will hear this particular case, it might bring some of sentiments and emotions also into the between, and therefore the conflict of interest might come here. So guys, what had happened? Honorable Chief Justice of India N.V. Raman had recused himself from adjudicating into the plea or hearing the plea which pertained to the Andhra Pradesh and Telangana with respect to the water dispute. So guys, it is an example. Guys, if you are following our newspaper analysis, then guys, a couple of months back, we have taken one more example also, where we have discussed about the Justice Pratibha Singh from the Delhi High Court. She also recused herself when she was hearing the privacy case against the WhatsApp. Guys, Justice Pratibha Singh, when she was an advocate, once she had appeared on to the behalf of WhatsApp, and now as against the WhatsApp, the privacy with against the WhatsApp, the case was filed into the Delhi High Court with respect to the privacy violation. She recused. She said that if I now will be hearing this particular case, this might bring the conflict of interest, because once into the private interest I had appeared. So she recused. So guys, these are the two examples that we can take. So that is all about this particular article, and now we'll be moving to the next article. Now guys, this particular article, it talks about the Air Quality Commission or the Commission for the Air Quality. Now guys, for this particular thing, the bill has been brought into the parliament. Now, before going into this particular matter, we will be seeing it from the very start. So guys, you might be knowing this thing that the winter pollution into the Delhi becomes a very big problem. Many a times the Delhi has been quoted as a gas chamber by even by the Supreme Court. Now guys, what happened? In order to solve the pollution of the winter, solve the pollution of winter into the Delhi, the government came out with an ordinance into the month of October 2020, and it established the Air Quality Commission, which will be looking at how this pollution can be reduced. Now guys, you know that the ordinance can be brought under article number 123 when either or both the houses of the parliament are not in session. At that point of time, parliament was not in session. So by using the article number 123, President of India promulgated the ordinance. Now guys, it has been provided that the ordinance is needed to be converted into a law within the 6 weeks when the parliament has convened. Now guys, the parliament got convened, fine, onto the January 29, fine, the budget session began. Now guys, but during, because the budget session was a very busy session, fine, and guys, before a kind of an ordinance needed to be introduced as a bill, it is also needed to be cleared by the cabinet. But guys, neither it was cleared by cabinet nor it was introduced into the parliament, and ultimately that 6 weeks time it got finished and the bill got, this particular ordinance got lapsed. Then guys, again this particular organization was brought by an ordinance, and now this particular ordinance is being attempted to create it into a kind of an act. So now the bill for the creation of a Air Quality Commission has been there. Now guys, this particular body which will be established, it will be a kind of a permanent body to address the pollution into the areas, that is the National Capital Region of Delhi, fine, into the Punjab, Rajasthan, Haryana and Uttar Pradesh. So these are the areas where the jurisdiction of this particular body will be prevailing. Now guys, this particular commission or the body which will be created, it will be having a full-time chairperson, and it will be having a wide range of members from the different sectors. It will be having the representatives from the different ministries. There will be the independent experts, there will be the environmental experts, etc. Now guys, under this particular National Commission for Air Quality, there will be the 3 subcommittees also which will be assisting this particular commission, that how it can perform its role. So there will be, number 1, the subcommittee on monitoring and identification. Then guys, secondly, there will be the subcommittee on safeguarding and enforcement, and thirdly, there will be the subcommittee on research and development. Now guys, you see this particular thing, already we have the Central Pollution Control Board at the level of center and the State Pollution Control Board CPCB at the level of state, and already the mandate has been given to them to control the pollution under the different acts. For example, there is the Environment Protection Act, there is the Air Act, Water Act, fine. So they talk about the pollution already. But guys, many times it has been seen that the pollution, it is not restricted to a state, rather it is a trans-state phenomena, and into that the different state pollution control boards, they come into a kind of a clash, and then the effective kind of decisions are not taken. Moreover, there is also a blame game which is played. So guys, here into this particular gap, the Air Quality Commission will be coming. Air Quality Commission has the power that it can issue the writs onto the different bodies with respect to their mandate, and the decision has to be then taken, responsibility has to be fulfilled. So basically this Air Quality Commission will be actually a kind of a body which will be bringing the convergence among the agencies, which will be bringing more synchronization and coherence among the different agencies, so that the pollution as a holistic problem of entire North India can be dealt, rather than a silo-based approach which is now being taken. Now guys, this is the entire Air Quality Commission. Now guys, when we talk about this particular commission, see, earlier when it was brought into the form of an ordinance, there was one provision which provided for the penalty as well as fines onto the farmers who are going for the stubble burning and who are leading to the pollution. But that particular provision was called as draconian. So guys, now into this particular new bill, the fines and penalties onto the farmers have been dropped, but still the provision with respect to the fine is there, which could be imposed onto the polluting industries or onto such kind of establishments which are causing this pollution. Fine. So guys, the provision of fine is there, but fine and penalty onto the farmer has been dropped. You need to keep it into your mind. Now, when we talk about the pollution problem into the Delhi, fine guys, it comes majorly from 2-3 important factors. Now, first factors come is that the stubble burning is carried around the month of October, fine, and that stubble burning leads to a lot of pollution. At the same time, guys, the festival season also comes on to the Diwali. There is a lot of cracker bursting that also leads to the pollution. Fine. Then, guys, the vehicular emissions are also there. Then all these three factors they get reinforced into the winters, because guys, into the winters, the cold air, it is resting most of the times near to the ground. The basically wind movement is very much less, so guys, the concentration of the pollutants, PM 2.5, sulfur dioxide, etc., it becomes very much high. Ozone, it also starts to get developed. Fine, because guys, just a few days back we have also seen one particular article by the CSE where it was said that the ozone creation, it is not a phenomenon of summer, into the winter also it happens. So guys, the creation of ozone, the creation of PM 2.5, PM1, all this happens and it reinforces it during the time of winter, because many of the factors come together. Now guys, it has been provided already by the Supreme Court that the earlier order where the NGT once banned the firecrackers, or provided that in some areas where the moderate pollution is there, only green crackers could be used. Supreme Court said that this particular decision is right, because under article number 21, right to life is supreme. So guys, onto that particular crackers there is kind of a restriction. Then comes the stubble burning. Now guys, onto the stubble burning, why the farmers go for the stubble burning? Why? Because guys, the kharif crop which they are going to harvest, now after the kharif crop will be harvested, the next rabi crop, particularly the wheat, which is more prominent here, it is to be sown. The window between the kharif and the rabi crop is very much limited. Now guys, they don't have a time that the stubble which have been left after they had harvested that kharif crop, it is to be procured, it is to be retrieved back. Time is not there, because the rabi crop has to be sown. So what they do, they go and they burn it. Fine. So this is particular thing is happening. Now it has been provided that there could be the three main solutions to solve this particular stubble burning. There needs to be an in situ treatment onto the spot treatment. There could be ex situ treatment, or there could be the change of cropping pattern. Now guys, when we talk about the in situ treatment, it has been provided that we need to give the farmers the equipment so that they can mix the stubble back into the soil. Now guys, into this particular direction, the Pusa Institute of Delhi has already developed a biodecomposer, which is actually a kind of a liquid solution which is basically applied onto the field, and guys, it decomposes the stubble there only, even it increases the fertility. So guys, this Pusa Institute's biodecomposer could be one of a thing here which could be utilized. Then guys, it has been provided that when we talk about this particular thing, providing them the equipments, providing them the aids, it has been absent largely by the state government, and then the farmers don't have any kind of incentive to procure it, and they are just burning it. They go for a very easy kind of thing which is possible. Then guys, the next is the ex situ management, and into the ex situ management, certain companies have been given a mandate that they need to collect the stubbles, fine, and they can use it for some other purposes. But guys, here many less companies have been identified, and they are reaching to the many less farmers, so it is also not very much effective. Now guys, changing the cropping pattern could be a one more thing, but guys, it will be taking a lot of time. Moreover guys, when we talk about changing the cropping pattern, particularly Punjab and Haryana, they are involved in growing of a rice. It is even more urgently needed, because guys, into the Punjab and Haryana, rice is not at all suited, because the rice needs at least 100 centimeter of rain, but into the Punjab and Haryana, it is barely 40 to 45 centimeter. So guys, changing of cropping pattern is more sustainable thing, but it will take much of a time. So guys, it has been provided that this stubble burning issue, it is needed to be addressed into much holistic manner, because until and unless it will not be seen, the pollution problem will not be coming to a fore. So government needs to come out with a kind of a scheme where farmers should be incentivized to remove the stubble, equipments need to be given to them, financial aids needed to be given to them, state of the art technologies are needed to be given to them, and the methods such as the direct seeding of rice needs to be promoted. Because guys, when we talk about the direct seeding of rice, it is a method where rice is directly sown into the land. Now this particular thing, basically into this particular technique, the rice crop, it gets matured early, and guys, here we see that the time window is very much limited. Now when by the direct seeding of rice, the rice will getting matured early, the farmers will have a long window, and into that they can deal with the stubble issue. Fine. So this is all what has happened. Now guys, holistic coverage we have taken of this particular article. I hope that you have understood it, and now we'll be moving to the next article. Now guys, this particular article has been taken again from the Hindu, and it is talking about the recent decision which has been given by the Kerala High Court, where the definition of the rape, which is contained in the section number 375 of the Indian Penal Code, has been extended. Now guys, this particular thing could be used as a reference when you are talking into the GS paper number 2 social justice, the steps that have been taken for the protection of the women. Now guys, it has been provided here. Now first of all, much of the legal jargons are there into that article. You don't need to go into that because for general studies point of view it is not usable. Now guys, what court has provided into the simple words, court has expanded the definition of a rape. It says that any manipulation of the body of a woman in such a manner as to simulate an effect providing sexual gratification similar akin to penile penetration, fine, will be covered into the rape. Fine. Now guys, earlier it was said that there needs to be a kind of a penile penetration, fine, or there needs to be a kind of a penetration into the vagina, urethra, anus, or such kind of an orifices. However guys, we have seen that even other kind of tendencies of sexual gratification has happened. For example, there are the acts where the penetration has been made between the thighs held together. So guys, even such kind of penetration, if it is happening between the thighs or any such other kind of body organ, that will also be covered under the definition of a rape. So simple takeaway that you need to understand is that if a person is trying to achieve any kind of a sexual gratification from a woman's body which might be similar to the penile penetration, then guys, those particular kind of act will be covered under the definition of a rape. Into this particular direction, it has been provided that any penetration which is made between the thighs that are held together, it will also be coming under the definition of a rape. Vaginal penetration, penetration into the anus, urethra, it is not necessarily needed. So this is one thing. Now guys, it is also a kind of a good thing that has happened, because thus making of a stringent laws also many a times leads to the deterrent effect which is needed to curb such kind of a heinous instances. So that is all guys which have been provided into this particular article. And now we'll be moving to the next article. Now, this particular article taken up from the editorial section, and guys, it is talking about the role of providing the education into the mother tongue to the students in order to enhance the efficacy of the education. Now guys, what has happened? We have covered into our articles earlier also that the 1 year of national education policy has been completed, and as this 1 year has been completed, the Prime Minister has announced many of the schemes. For example, the academic credit bank was announced, into which the colleges have started to participate. And guys, another initiative is that it has been provided by the AICTE, that is the All India Council of Technical Education, that the BTech programs will be offered into the 11 of the native languages as a part of the new education policy to provide education into the mother tongue. And into this particular direction guys, already the 14 engineering colleges, if the 14 engineering colleges across the 8 states, they had started to offer the courses into the regional languages already. So guys, this is something which has happened. Now it has been provided that when we talk about the role of native languages, role of mother tongue into the education, it is very much important. Why? Because number one, it instills the confidence into the students from the poor, rural and tribal backgrounds, because many times they are not fluent into the English, and when we are just providing the education into the English, particularly into the scientific courses, they feel basically underconfident that they cannot understand the complex concepts. Moreover, the UNESCO had also provided this particular thing, that learning in mother tongue is germane to building the self-esteem, self-confidence. Further guys, it has also been provided that if we just ask from the students themselves what they prefer, then a survey was conducted by the AICTE in 2021, and it was said that 44% of students, they voted in favor of studying the engineering into their mother tongue. So guys, even there is a kind of a support by the student community also. Moreover, it has been provided that when one learns into the mother tongue, it enhances the learning efficiency. It basically builds into the contributes into the better learning outcome. So on to that particular ground also, the providing of courses into the mother tongue is very much important. Now guys, if we see the global practices, they have also justified this particular thing. For example, into the South Korea, we can see that into the 70% of the universities, they are teaching the courses into the Korean language. Moreover guys, when the parents were becoming fascinated with the English, already the South Korean government in 2018 had banned the use of English prior to the 3rd grade into the school. Then guys, into the Japan, university programs are being taught into the Japan. Into the China also, the universities, they are using the Mandarin as the medium of instruction. Then guys, when we talk about the countries into the Europe such as France and Germany, they are also following the similar practice. For example, into the France, there is a strict French only policy with respect to the medium of instruction into the schools. Then guys, into the Germany, 80% of all the master programs, they are being offered into the German. So guys, these countries also focus that the regional languages, native languages are very much important. But into the India, we have fascination with the English, and majority of the higher education courses, they are taught into the English. Fine. Now into this particular direction, guys, the NEP had provided that at least till the class 5th, and if possible to till the class 8th, the students needed to be educated into their mother tongue. So this is one thing which has happened. Now guys, into this particular direction, it has been provided that the private universities, they need to join hands with the government, and to on to their own initiative, they need to come out with the technical courses into the regional and native languages. Now, but the problem comes is that we don't have the enough of the textbooks. We lack a high quality teaching material textbooks. So guys, into this particular capacity, the material is also needed to be prepared. Now, what could be the way forward here? So guys, here we can see a kind of a case study where a collaboration has been done between the AICTE and the IIT Madras, and they are translating the courses which are there onto the Swayam platform. Guys, the Swayam platform is a platform where massive open online courses have been provided. So whatever content is there, for that they are providing the text material into the native regional languages. So on to such kind of line, guys, much more collaborations are needed so that high quality teaching material, text material can also be prepared. So guys, this is a kind of a thing that we need to explore. Moreover, the great Indian physicist and Nobel laureate Sir C.V. Raman had also provided that we must teach science in mother tongues, otherwise science will become a highbrow activity. It will not be an activity in which all people can participate. So this is actually, guys, the role of the regional languages, native languages, vernacular languages in promoting the education. So this particular dimension you need to keep it into your mind. So that is all about this article, and now we'll be moving to the next article. Now guys, this particular article, it is just talking about some of the major issues that are there into the GST. Therefore, it is kind of an important thing for the GS paper number 3, taxation and related matters. However, guys, into the article, much of a substance or much of a thought-provoking ideas are not there. It is just talking about the general issues which are there into the GST, and it just says that now the time has come that the GST 2.0 or a refined or a reformed version of GST is needed to be brought. Now, when we talk about the GST, it is the goods and services tax which was introduced into the India as a unified indirect tax reform by the 101 Constitutional Amendment Act. Now it has been provided into this particular article that so many of years have been there, but still there are certain issues which have not been addressed. For example, guys, it has been said that there is an asymmetry of power equation between the states and the center. Center has an upper hand, and guys, we have seen into the times of pandemic that the states, the center, for a considerable time even withheld the due that was there for the state. So guys, this power asymmetry is needed to be reformed. It was provided that though the first 100 and basically the 115th Constitutional Amendment Bill, which got converted into the 101 Constitutional Amendment Act, it provided with some kind of adjudication measure, but guide onto the ground, it has not been translated. So the power equation is not balanced. Then it has been provided that, guys, there are many of the exemptions from the registration under the GST, and basically this particular thing has provided a kind of a situation where many number of the firms could stay under radar. Then next it has been provided that, guys, many of the things have not been included. For example, the petrol and petroleum products have not included, and guys, petrol and petroleum products tax onto them basically have a huge kind of quantum, so it needs to be included. So guys, these are certain of the issues which are needed to be seen. Moreover, with respect to the compliance, with respect to the filing of the GST, much of the complications are there which are also needed to be reduced, so that, guys, a kind of a efficacy and a kind of a easiness in filing the tax would be attained. Guys, if we just take one particular thing here apart from this article, the Adam Smith, he provided that a taxation needs to be easy. If it will not be there, then people will not file their taxes. So guys, into the canon of taxation, a kind of a simplicity needs to be there, which is not there into the GST. So this also needs to be included. So guys, this is just the idea which has been there, and apart from it, there is nothing much very substantial or directly relevant to the UPSC. So that is all about this particular article, guys, and now we'll be moving to the next article. Now guys, this particular article has been taken from the editorial section, and it is talking about the fundamental right to strike, and therefore it will be important under the GS paper number 2, rights and related issues. Now guys, what has happened recently, the Essential Defense Service Bill 2021 has been brought up into the parliament, and this particular bill talks about the maintenance of essential defense services, and it has been provided that whatever establishments will be given the status of the essential defense service into those establishments, the strike will not be allowed. So this thing, it has happened here. Now guys, it has been provided that many times strikes are resorted by the civil servants, by the public service officials, whenever they want that their demands need to be met. But it has been provided that even the Gandhiji provided that the public establishments cannot be treated with the ordinary establishments. The officials which are employed there, they have a kind of a special responsibility. So guys, it has been provided that as the strikes are not being allowed into the defense utilities, the state governments already had brought such kind of laws already. For example, the Madhya Pradesh and Chhattisgarh, they have the Civil Services Rule of 1965, which prohibit the demonstration as well as strikes by the government servants, and it direct the competent authority that whenever there will be a strike, it needs to be treated as an unauthorized absence. It has been provided that even under Article number 33 of the Indian Constitution, Parliament has a power that by law it can restrict or abrogate the rights of the members of the armed forces as well as of the analogous forces, fine, which are charged with the maintenance of public order. Fine. It has even been provided that within the scope of Article number 19 subclause 4, even the right to form an association cannot be given to the member of armed forces, analogous forces, etc. So it has been provided that guys, many a times the right to form association, and after forming the association, right to go into the strike cannot be given into the public utility services. Fine. Even the fundamental right under Article number 19 subclause 1 subclause A doesn't mention the fundamental right to strike. Moreover, it has been provided that into one of a case, that is the TK Rangarajan versus Government of Tamil Nadu, the Supreme Court had very clearly provided that the employees have no fundamental right to resort to the strike. So guys, basically all these are the justifications that how the state can take up the right to strike, and it will not be the violative of fundamental right. So here guys, a kind of a pro argument for this essential defense service bill has been made. Guys, if you remember, a couple of days back we have already discussed this particular bill. So guys, this is the justification. So if a question comes, we can utilize it. So guys, that is all about this particular article, and now we'll be going to the next article. Now guys, this particular article, it talks about the role of women, particularly into the research, drug discovery, into the science, etc. Now guys, it has been provided into this particular article that the masculinization into the science has been very much evident from the start. It has been provided that the women's often their recognition is not their endeavor, their effort is not recognized, and the science has been perceived as a masculine format and domain, and it is dominated by the men into the leading universities. Now guys, into the article, it has been provided that Kathleen Carrico, the lady that you can see into the picture, she played an important role into the development of COVID-19 vaccine onto the mRNA platform, and it was a revolutionary thing that was done. And the women like the Kathleen Carrico, they are breaking the stereotypes and the prejudices that are existing, and because of these prejudices and stereotypes, the women into the STEM has been very much less. Guys, STEM stands for the science, technology, engineering and mathematics. Fine. It is believed that women might not have the capabilities, so therefore they are not promoted to go into these careers, but the women like the Kathleen Carrico is breaking up such kind of stereotypes. And guys, it has been provided that in fact there are many of the women who had led important role into many of the research and such kind of programs. So we need to appreciate the effort of the women. Now guys, into this particular article, entirely the personal experiences of the Kathleen Keroke has been talked about, but that particular thing is not important for our UPSC exam. You can clearly ignore it. So friends, that is the key idea that has been given into this particular article, nothing more than that. So that is all, and now we'll be moving to the next article. Now guys, this particular article talks about the recent steps that have been taken by the states of Assam and Mizoram, where they have withdrawn the FIRs that they filed onto the political leaderships from the respective states. Now guys, recently we have seen that the Assam and Mizoram, they involved into a flare up onto the boundary matter. Now guys, into this particular article, it has been said that the withdrawal of FIR is a kind of a positive thing. Apart from this, nothing important is there into the article. However guys, as we are talking about the Assam-Mizoram boundary dispute, it is the most recent and latest federal dispute that had emerged, and the federal disputes and issues are clearly mentioned into the GS paper number 2. Though guys, into this article nothing important is there, but on to 28th July, we have discussed this entire Assam-Mizoram dispute way back from 1875. If you have not seen it, please go and watch it. Fine. So that is all just into this particular article. And now we'll be moving to the next article. Now guys, this particular article talks about a recent reform that the government has taken into the education sector, and it will be important for our GS paper number 2 under the topic of social justice education. Now guys, what government has done? Government has started the Samagra Shiksha Abhiyan 2.0. Now under the Samagra Shiksha Abhiyan 2.0, number 1, the Samagra Shiksha Abhiyan has been extended to the 2026, and number 2, within the Samagra Shiksha Abhiyan, the existing entitlements that were being given, they have also been increased. We will see it what has happened. Now first of all guys, when we talk about the Samagra Shiksha Abhiyan, it is a comprehensive and integrated program which covers the school education from preschool level to the class 12th. Now, the Samagra Shiksha, it aims the qualitative education, gross enrollment ratio is to be enhanced, the equity, parity into the education needs to be improved. Now guys, when we talk about the Samagra Shiksha Abhiyan, it was created after subsuming the 3 of the schemes into the education, that is number 1, the Sarv Shiksha Abhiyan, number 2, the Rashtriya Madhyamik Shiksha Abhiyan, and number 3, the teacher education. Now guys, under the Samagra Shiksha 2.0, it has been provided that first of all, the direct outreach will be provided to the student. There will be the child-centric interventions. Directly the students will be provided 500 rupees through the direct benefit transfer through the IT-based platform. Now guys, these 500 rupees they can use to buy the entitlements that are guaranteed under the Right to Education Act. They can buy the uniform, they can buy the stationery and other educational aids that they need. Moreover guys, it has also been provided that the incentive that is being given to the children with the disabilities, it has been increased to 5,000 rupees. Moreover, 6,000 rupees transport incentive per annum will also be given to the students who are coming from the difficult areas. So guys, these are some of the entitlements that have been guaranteed, as well as the duration has been extended. So guys, this is the latest education reform that has been taken. Please do utilize this into your answers. So that is all, and now we'll be moving to the next article. Now guys, this particular article talks about the extension of the fast track courts. Now guys, what it provides, first of all we will see. Guys, we have seen that into the India there are many of the cases which linger for year after year. But there are some specific heinous rape cases which we want that immediate justice should come. Into this particular direction guys, the background goes like this. In 2019, a centrally sponsored scheme was announced by the government where it was said that for the speedy resolution of the rape cases and the cases under the POCSO, that is the Prevention of Children from the Sexual Offences Act, more than 1,000 fast track special courts will be established. Now guys, first of all, these fast track courts, they were given a specific mandate that they needed to dispose at least 41 to 42 cases in each of the quarter and at least 165 cases in 1 year. One fast track court was given such kind of mandate. So it was believed that much of the backlog for the rape cases will come down. But guys, number 1, it has been seen that until now, not the entire 1,000 fast track courts have been established, just 597 were set up. And guys, basically they were also going to expire this year. So what has happened? The nod has been given that these fast track special courts, they will be continuing for the next 2 years, and additional financial outlay has also been sanctioned. So guys, this is a good step in order to provide the speedy justice to the rape victims. So that is all guys what has happened into this particular article, and now we'll be moving to the next article. Now guys, this particular article, it talks about the MPLADS fund which have been lapsed. Now guys, into this particular article, first of all, there are little bit of technicalities which might not be very much relevant for the exam, but still we will see what has happened. Now, first of all, guys, what is this MPLAD scheme that we are talking about? So basically, the MPLAD scheme, it was formulated in the 1993, where it was provided that the member of parliament need to given some money so that they can use at their own disposal within their constituencies to sanction some kind of works with respect to building of the durable assets work, which might bring some of social justice to the members of their constituency. Now, guys, under the MPLADs, 5 crore rupees are given to every MP. Now guys, this particular scheme right now is under the Ministry of Statistics and Program Implementation. Earlier it was under the Ministry of the Rural Development and Planning. Now guys, this particular thing has happened. First of all, into the time of pandemic, MPLAD scheme has been suspended for the 2 years. But now guys, it has come into this particular article that there were already the projects also, or there was already sanctioned money also under the MPLADs which was not taken up. So it was asked that, okay, you have suspended it for the 2 years, but give us the money which was sanctioned for the earlier years. Now into this particular direction, guys, it was provided that when such kind of money was asked, then guys, what happened? This money was given onto the March 2022, and it was said that the money needs to be utilized before the 31st March. Just 1 week time was given for the utilization of the pending funds. Guys, there were the 2200 crore rupees pending fund of the earlier years. They were sanctioned on 22 March, and the date of 31 March was given, and it was said that if it will not be utilized, the money will be lapsed. And now guys, as just half of the money got utilized, the other remaining half money had got lapsed. So now this particular thing is being questioned that this is not the way. In 1 week only, such large money cannot be utilized. So guys, this is just what has happened. Fine, apart from this, nothing more important into this particular article. So guys, that is all about the today's newspaper analysis. Guys, I believe that you are liking the initiative and you are finding the utility of this initiative. Please do spread the initiative. Thank you so much.